running for 10 minutes for us this morning, so if you'd like to begin
Yes,
your
thank you,
submission,
Mr. Chairman, members of the committee, for this opportunity to address you. I'm going to be very brief in my introduction and allow most of my time for your questions. And what I want to address is the sovereignty of Parliament. In the last submission, you heard what was another challenge to it. And in my submission, we have a situation where the sovereignty of Parliament is under challenge in the courts and from members of the legal profession. One of their weapons is the undefined principles of the treaty. The bill, if enacted, would remove that weapon. The behaviour of some of our senior judges suggests they think they are entitled to make law, to ignore Parliament's laws or to twist them into a shape they find more congenial. The most recent judicial excess occurred on the 2nd of December last year. In the Edwards case, the Supreme Court was so eager to try to frustrate the progress of the Matter Amendment Bill that it rushed out what it called a judgment. It wasn't a judgment, it was a pronouncement that the court had no jurisdiction to make. When the court announces the outcome of the claimant's claims, only then will there be a decision. 42 KCs warned that the courts might not enforce this legislation. Opposing the bill, the Law Society claims that the treaty and the principles limit Parliament's lawmaking power. In our free and democratic society, ultimate power rests with the people. They exercise their power by electing you to represent them. And that is why Parliament is sovereign. The lawyers think the Supreme Court has the ultimate power. The Supreme Court has been acting as if it thinks so too. They see the ordinary people and you, their representatives, as untrustworthy decision makers who can be second guessed by persons implicitly claiming superior intellect and wisdom. Parliament should be jealous of its sovereignty and be clear that unelected decision makers must act in accordance with the law and accept the sovereignty of Parliament like everyone else. The bill stops the principles from outflanking the sovereignty of Parliament. My proposed amendment to the Lawyers and Conveyancers Act would remind lawyers of the duty they owe to New Zealand's Constitution. The rest of my time is for your questions.
Thank you, Gary. Members, we've got time for questions. I'll start with Todd Stevens.
Thank you for your presentation. Just so I'm clear, basically, as I understand it, Gary, what you're saying is because Parliament left the principles of the Treaty of Waitangi undefined, there's now been obviously this kind of jurisprudence and also governments have actually said what the principles are. So are you, in your opinion, it's quite legitimate for Parliament now to be able to go back and define what the principles are?
Yes, absolutely.
And then you mentioned at the start also this attack on parliamentary sovereignty. Because again, this is, I think, and again, we heard this in the last submission, the idea that actually there should be basically two governments for New Zealand. But it's just one of the issues with, because again, in 1989, the Labour government, as one of its principles, so again, a government just stating what the principles are, actually said that Parliament was sovereign. So is this one of the issues with not having a definition, is that principles can change over time and people are uncertain?
Well, they can change according to the whims of those who are dealing with them at a particular time. And I think it all comes back to the fact that Parliament is sovereign, representing the people. It must make the laws, and in respect to the principles, it must say what they are. If Parliament doesn't do that, then it just leaves a vacuum, which may be filled by people who wish to push their own barrows.
Thank you. Thank you. I'm as guilty of this as anyone, but if we can try and get the questions relatively succinct, we'll get through. We have a question from Duncan Webb and then Tuck Ferris.
Judd, thank you for that, and I will keep this short. I'm just interested in terms of your views of parliamentary sovereignty, because I guess my question is this: do you accept that Parliament in part gets its authority to govern from the Treaty of Waitangi, and if so, how is it then appropriate to go back and rewrite it?
No, I don't accept that Parliament gets its sovereignty from the Treaty of Waitangi. Parliament gets its sovereignty initially from it having been conferred by the United Kingdom or British Parliament back in 1840, and what the treaty did was to indicate the assent by the chiefs who signed that they were accepting of that happening. Of course, you have to remember what the situation was.
So how did the British Crown get the right to assert the authority of Parliament, which of course didn't happen until the 1850s, over the territories of New Zealand?
The British, we're really going into a history lesson here, but when the British were initially asked to intervene in New Zealand's affairs by the chiefs, and as a consequence, Busby was sent over as the resident. The British became involved in a governmental way in New Zealand, and then as a result,
I don't think you can answer that question. It's probably appropriate to give a question to another member.
Thanks, Duncan. I'll chair the meeting from here. Thank you. Mr. Judd, are you finished with your answer? If you are, we can move on to the next question.
No, I'm finished. Didn't really come here to talk about
Thank you. Question now from Takata Ferris.
Morena Matua, thank you for your time this morning. I'm just wondering if you agree with the notion that actually countries are sovereign and parliaments are actually sovereign by virtue of an act of their own making. Would you agree with that?
No, I think that sovereignty resides with the people. They have the ultimate power, and in a democracy, the people represent others elect others to represent them, because from a practical point of view, the people cannot, as a great big group, govern. So they have to, in effect, delegate their authority to representatives. But the point is that the people are ultimately sovereign. That's what democracy is all about. And if we want to have and retain a democracy, then we must be firm about that, and we must reject as firmly as we possibly can any suggestion that any particular group of people within the country have power over others other than the elected representatives.
Well, I see we're down to a minute, Matua, so I might just ask you one more. I agree with your point that the peoples are sovereign. And Te Tiriti o Waitangi is a document signed between two sovereign peoples, the original sovereign people of this country, Māori, and the monarchy of England, the Queen of England at the time, who represented her sovereign people. Would you be happy with that characterization of Te Tiriti o Waitangi, the coming together of two sovereign peoples? And if you are, do you think it's okay that one group changes the deal without informing the other?
Well, no, I don't agree with that characterization, because it's impossible to characterize a collection of warring peoples as
the British, you mean the European warring peoples?
No, I'm talking about the various tribes who were fighting all around the country from time immemorial, in particular within the years preceding.
Gary, unfortunately, that's the time we've got for the submission, so I'd like to acknowledge your submission. Thank you for being with us here this morning. Now go.
How the hell did he? Well, he probably is an experienced lawyer, just doesn't quite like.
Do you know what I don't like? Is we've got all these lawyers and doctors that aren't even Māori speaking for Māori or tangata whenua when they don't even have a clue about tikanga o kawa. They may have a doctorate about it, but they've only seen it in the books. They've never been on the marae. They've never gone to the kaumātua. They may have, but they've got their information from it, but they've used that to their advantage. But they've never gone and picked up a tea towel, or they've never gone into the back of the hangi pit to pull out the hangi.
Oh no, I haven't even got that far.
Or even burying someone in the urupa.
I like my hangings, but no, I don't think I got that far. But yeah.
No,
oh well, Sam, I'm going to have to bring you back to the marae to make a hangi, eh?
You thought out a time, and I am very open to it, as long as you make it a Sunday.
Something I noticed on Friday when I was watching through literally all of these is that a lot of people show that they might have learned experience, but they don't have lived experience.
Correct, because they're not Māori.
Notice that there is a difference.
Exactly. Yes, so much. And it is so many people who, a textbook approach on something is very different from literally learning it. Like, put it this way. Oh, I've never driven a manual before. I've only ever driven automatics, but I understand how a manual works compared to someone who goes, I've driven manual all my life. I actually know how manuals work and I know how gearboxes properly operate. I don't just put the Prindle in D and drive off. and anyone who remembers the Prindle, that would be off the Sweet Life of Zack and Cody of London, one of London's ways of calling it. Shall we move on to the New Zealand Māori Council? And I think Jordon's having his lovely fun of going backwards and forwards again.
I think it's when he's looking at something else on his phone. It's just popping him out for a moment.
Yeah. Oh, yes, it does that. Yes, I remember that when I was like sickening just watching it on a smartphone. It was an absolute pain in the butt of going through there.
Yeah. Are they the next one?
Yeah, sorry.
That's all right.